Hello and a warm welcome to the EDRM Global Webinar channel. My name is Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with our trusted partner, eDiscovery Today. It's called Important eDiscovery Case Law Decisions for November 2024. Our faculty experts are Doug Austin, Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your feedback and questions in the console. Questions will be answered during and at the end of the webinar. And this webinar will be available for replay at your convenience for the next quarter, as are all of our EDRM webinars. Slides will be available after the webinar. Kaylee Wallstad, EDRM's Chief Strategy Officer, is here. Will you please tell us what resources are available, Kaylee?
Absolutely. And as always, I look forward to this fantastic monthly series. It's over 4 years, and thank you to all of the faculty for the fantastic job that you do. We're also loving On 24 with so many more ways for you, our audience, to engage. If you check your console to the right of your screen, you'll see the question mark icon. If you click it, this is where you can type in your questions for today's faculty. You'll see the paperclip icon. That is for related content. If you click on it, you'll see today's resources carefully curated just for you. There's an On24 engagement tools description for you to download to help you better engage with the platform. There's a link to click to subscribe to eDiscovery Today blog and never miss a thing. It is definitely my favorite way to start the day. There's also a link to learn more about the Honorable Judge Peck and how you can engage with him. And also a link to order a copy of Tom O'Connor's spicy newish book, eDiscovery for the Rest of Us, recently updated in collaboration with EDRM's trusted partner, NextPoint. Check it out. It is outstanding. And then be sure to save your seat for next month's wrap for the year, December. It will be December 12th, but it's the best cases of 2024, so you will not want to miss that. And then up next on EDRM's webinar channel, December 3rd, creating thoughtful work structures for cross-functional teams using the GOSP Models 101 with the always brilliant Charisma Star. And last, huge favor ask. If you could please share 5 minutes of your time to take the acclaimed eDiscovery Business Confidence Survey, we would be most grateful. And then just like Zoom, you'll see the smiley face emoji. If you click it, there's many more reactions that you can click, and we highly encourage you to engage with them. We're having a lot of fun with them on this platform. And if you click the Twitter bird, you can follow EDRM and eDiscovery Today on LinkedIn. Back to you, Mary.
Thanks, Kaylee. And our faculty, starting with our wonderful curator and moderator, Doug Austin. Doug Austin is the editor of eDiscovery Today, a daily blog about eDiscovery, information governance, cybersecurity, data privacy, and artificial intelligence trends. He also includes best practices and case law in his blog. Doug is an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and governmental clients. Doug has, yes, published a daily blog since 2010 and has written numerous articles and white papers, receiving the J.D. Super Reader's Choice Award as a top eDiscovery author and top cybersecurity author. Doug is presented at numerous webcasts, events, and conferences, including Legal Week New York, ILTACon, Relativity Fest, the University of Florida eDiscovery Conference, the Masters Conference, and many local and regional conferences. Tom O'Connor, who is the director of the Gulf Coast Legal Technology Center, is a nationally known consultant, a speaker and writer in the area of computerized litigation support systems. Tom's consulting experience is primarily in complex litigation matters where he's worked with firms of all sizes, most recently the plaintiffs in the BP litigation. He's also been appointed as a technical consultant by various federal and state courts on cases dealing with large amounts of electronic evidence. And as Kaylee said, his most recent edition of his popular spicy book, eDiscovery for the Rest of Us, was launched at Legal Week with EDRM's trusted partner, NextPoint. And of course, we have our wonderful, honorable Judge Andrew Peck. He is a Band 1 Chambers-ranked senior counsel at DLA Piper, and he served for 23 years as the United States Magistrate Judge for the Southern District of New York. And before his appointment to the bench, Judge Peck was in private practice for 17 years, focusing on commercial and entertainment litigation, including copyright and trademark matters, with extensive trial experience. At DLA, Judge Peck advises on copyright and trademark matters and serves as a resource for the firm and its clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck particularly advises on innovative and efficient solutions to the challenges of information management, both within and outside the litigation context, including cross-border discovery issues. He speaks frequently at conferences concerning eDiscovery issues. And since joining DLA Piper, Judge Peck has been retained to serve as special discovery counsel to clients and law firms and to submit expert reports on eDiscovery issues. EDRM is grateful to all three of these gentlemen for their service on the EDRM Global Advisory Council. And with that, Doug, do we have some cases to deal with?
We certainly do, Mary. Thanks, and welcome everybody to our November 2024 case law webinar on the EDRM network. We're thankful that you're here. We do indeed have another 6 unique cases, indeed, to discuss this month, and those cases address disputes related to compliance with an ESI order, organization of files and production, relevance of discovery to a Monell claim, redacted information for class certification, topics in a 30B6 deposition, and production of a destruction unavailable log. Of course, we do welcome questions, and we'll try to get to as many as we can. And you'll be thankful to know that we'll send out a copy of the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organization's clients or partners. Disclaimers for webinars are great served hot or as leftovers on demand.
Oh,
that's good for those keeping track at home.
For those of us with the scorecard,
we didn't bet beforehand how many there were going to be, so
it was.
I'm going for double digits on this one.
Yeah.
All right. Well, we'll see. You knew there was going to be one on this slide because there always is. All right. Anyway, we digress. Before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistance site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 39,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So with that said, let's get into the cases. Our first case, in fact, our first three cases all have a Yogi Berra deja vu all over again component to them. And this one was suggested by Judge Peck. Here, as he did in his ruling in the StubHub case last year, California Magistrate Judge Thomas Hickson opened the order by stressing the importance of being able to comply with an ESI order, stating, so here's the deal with a court order, especially one that you stipulated to. It's an order, so you have to comply with it. If you learn new information that makes it seem like it will be difficult or impossible for you to comply with the order, then you should move to modify the order with reasonable diligence, explaining why the order has become difficult or impossible for you to comply with. You might win your motion, or you might lose, depending on how good your argument is. But that's what you're supposed to do if you find yourself in that situation. What you're not supposed to do is pretend like the order doesn't exist or pretend that your violations are somehow a form of compliance and then hope your opponent doesn't point out what you're doing. In 2023, in this case, the parties had stipulated to an ESI order that the court approved. Paragraph 1 of Appendix 2 set forth the protocol for privilege logs, which you can see there in the second bullet point. Judge Hickson stated the issue here. As plaintiff points out in her motion to compel, Meta's privilege log does not comply with paragraph 1 of Appendix 2 of the ESI order. In this order, the court expresses no opinion on what information is required to substantiate a claim of privilege under the case law or under Federal Rule of Civil Procedure 26b-5. Here, a plaintiff is complaining about Meta's noncompliance with paragraph 1. That makes most of Meta's arguments unnecessary to consider, as Meta mostly talks about case law in Rule 26b-5 and says little about paragraph 1 of Appendix 2 of the ESI order. Granting the plaintiff's motion to compel Meta to comply with the ESI order, Judge Hickson stated, Meta has a lot to say about how compliance with paragraph 1 of Appendix 2 is difficult or impossible. Meta says that it is difficult for it to identify all the individual authors and suggests it may not be possible for it to identify all the recipients. You know where those arguments belong? In a motion to modify the ESI order. Since no one has asked the court to modify the ESI order, the court expresses no view on whether there is good cause to do so. I think that's a hint for Meta on what they should do next. So, Tom, do you think there are any strategic reasons a party like Meta might fail to comply with the stipulated ESI order regarding privilege logs? Is it simply a case of better to ask forgiveness than permission?
Well, I hope that's not their strategy, because that's not a very good strategic decision. I'm not sure what strategic decision makes sense when it's a stipulated order. We're not talking here about there was an informal agreement, there was some emails exchanged, we're going to do this, we're going to do that. It's not even we agreed to this in the meet and confer. This is an order. Like the judge said, here's the deal with a court order. You got to do it. So I just don't know. I mean, in that very first paragraph, the judge seems to give, you're not supposed to pretend there isn't an order or pretend that your violations are somehow a form of compliance and hope your opponent doesn't point out what you're doing. They at one point, I'm mindful always of our old friend Brownie Marion used to say, you should never attribute to malfeasance what could be explained by simple ignorance. That their insistence on cost and time and expenses may be conflating the issue of proportionality, which doesn't really apply here, as the judge pointed out. Your remedy is to bring a motion to change the order. So I would hope that they didn't do that deliberately and they got confused, but too much tryptophan, right?
Maybe. Well, I guess they can't make that excuse this time of year. Right. Back when the order was, but maybe in the future, who knows? So Judge Peck, one of the things I thought about is it doesn't appear that the plaintiff requested costs and fees in their motion to compel. Should they have, considering the issue pertains to compliance with a court order? And if they had, and you were the judge, would you have granted fees and costs?
Often it is more bother, even for the party seeking the costs, let alone for the court to seek costs. Now, it's unclear to me whether this was full-blown motion practice or the simpler letter motion approach that is very prevalent in the districts of California as well as New York. The cost of making a motion saying, here's the stipulated ESI protocol, here's what it says, here's what Meta didn't do, end of motion, the amount of money involved in a cost motion just may not have been worth it. And I got to tell you, from the court's point of view, it's not like one could just say, okay, plaintiff wants costs. They have put in what the bill they sent to their client. They want X $1,000. I award them that. You gotta, if necessary, determine what the hourly rate was of the lawyers who worked on the motion, how many lawyers worked on the motion, and how many should not have worked on the motion, et cetera, et cetera, et cetera. So from the court's point of view, it's a real pain in the neck.
Yeah, I can understand that. So, good point here. This doesn't seem like this should have been a heavy lift motion to compel compared to some we've seen and at least one we'll see later on in this webinar. So, Mary, do you see anything out of the ordinary in paragraph 1 of Appendix 2 there in bullet point 2, or does that seem like a pretty standard specification for a privilege log?
Well, it looked pretty standard to me. I broke it down and because like the beginning date and end date, I'm like, oh, that could be problematic. But what the core of this is that they're not sure who they distributed the material to, which is a core element of protecting privilege, is keeping it to a small circle. So I think that this case might be a sleeper case. It actually surprised me.
Yeah, a great point. And guess we will see. One would presume that Meta may be coming back with a motion to modify the ESI order. And if so, we'll have to look for that and see what they say. So it will be interesting to see that. In the meantime, let's get to our next case, which is another deja vu all over again case, as it's a ruling in a case that we covered for a different ruling for back in August of last year. In the case, plaintiffs sent each defendant a request for production shortly after filing suit. Defendants resisted the request for more than a year and a half, but several months ago, they finally provided a link to more than 180,000 pages of electronically stored emails and documents. That didn't satisfy plaintiffs, who asked the court to compel defendants to fully respond to the request for production by producing all responsive, non-privileged documents in native format with metadata and with sufficient specification and identification of documents produced. They claimed that defendants dumped the documents at their feet without any discernible organization or relevance to the specific request propounded, so they could not tell which discovery requests the documents were responsive to. Defendants insisted they met their discovery obligations as they identified by bait stamp which files were responsive to plaintiff's request for the non-emails, and they contended they need not do the same for the emails because those documents were provided as they're kept in the usual course of business. In analyzing the issue in the application of FRCP Rule 34B2E, Florida Magistrate Judge Tal Dudek stated, starting with subsection 2, which directs parties to produce ESI in a reasonably usable form, or that in which let me try that again, or that which it is ordinarily maintained, defendants have produced the responsive emails as TIFF files with load files which retain the relevant metadata and essential functionality of the native file format. That is sufficient. He added, plaintiffs complain that defendants have not identified the request to which email or corresponds, but that's not required. Under Rule 34, a party may produce documents as they are kept in the usual course of business or organize and label them to correspond to the categories in the request. This normally requires, 1, preserving the format of the ESI, and 2, providing sufficient information about the context in which it is kept and used. Finding that both requirements were satisfied, Judge Dudek ruled, contrary to plaintiff's suggestion otherwise, there's nothing in Rule 34 that requires a party to elect to produce documents as they are ordinarily kept to also organize them. Thus, because the mirror images were produced as they are kept in the usual course of business, defendants have complied with Rule 34B2EI, and no further organizing or labeling is required with respect to these documents. So, Judge Peck, do you think the defendant's resistance to the plaintiff's request for over a year and a half should have influenced Judge Dudek's ruling?
I mean, I am sure it influenced how the judge thinks about the parties in the case, but it really is not relevant to the dispute before the court of form of production. So, and there is a split of authority in the courts about how the two subdivisions of 34B2E apply. So, you know, if this were a Jeff Cole decision or something, he might have said something about the long delay and how bad it was. I'm sure the judge here was thinking about that, but didn't need to refer to it or use it in ruling on the matter.
Yeah, that makes sense. So Mary Judge Dudek said that defendants have produced the responsive emails as TIFF files with load files which retain the relevant metadata and essential functionality of the native file format. Do you agree that is producing documents as they were kept in the usual course of business?
It's interesting. It's sort of a term of art, the usual course of business, because you would think that would mean native files. But
Right.
it's sort of a community standard that producing the load file with relative file paths and the extracted text and the metadata, that's sort of what we consider the usual course of business. But certainly emails that are just like text, the thing that would be missing there would be the header information. Like if you wanted to, go deeper on the email. Otherwise, you're talking about attachments, and what people are most concerned about are things like red lines, the formula in spreadsheets, or speaker notes in PowerPoint.
Mm-hmm. Yeah. And those can be useful sometimes. So Tom, what recommendations do you have for our audience to avoid form of production disputes like these?
Well, this is what meet and confers are for. Try to, iron these things out and have an understanding about what you're going to get or what they want. The meet and confer is designed to identify what you have, what format it's in, where it sits now, and how you intend to produce it. Get that ironed out at the meet and confer, and then enter into an exchange protocol. To Mary's point, I always recommend if there's going to be a quote unquote concordance load file, that there also be either a link to the native file or another paragraph that has an agreement that says if there's any dispute about the documents, we'll produce the native file, so that you kind of cover that base in there. But I think that's, that becomes a real issue, whether those are native files. The other thing is to act in a prompt manner. I mean, the court points out the defendants resisted the request for more than a year and a half. Why? Let's get that on the table. What's the problem? Let's get that out here. Why have a year and a half if you're going to produce these documents? Why a year and a half to get them out the door? Then be clear on the rule. The judge is saying, well, you didn't really understand the rule. The rule doesn't require them to do that if they produce native files. The rule says, they can produce native files or kept in the ordinary course of business, or organize and label. So understand that. I think there's just some nuts and bolts things starting at the very front end in a meet and confer that you could do to avoid these arguments 2 years down the road.
And in addition to the meet and confer issue, your request for production should say what format and how you want it produced, and that would require the responding party to agree or to say, no, you're being excessive or whatever. We're going to do X, at which point it would have been teed up for a further meet and confer and or a trip to the judge before documents are produced. So they lost the opportunity, apparently, to do what the rules say about form of production, and therefore it came up as a request for a do-over.
Right. Yeah. Always much more, much better to raise the issue before the production happens, the dispute, than afterwards. So certainly great advice, and we will move on to our next case. Is it safe? Some of you will get that joke when I tell you this next case involves a civil rights claim by the plaintiff regarding inadequate dental treatment received while incarcerated at Pierce County Jail. This specific order addressed plaintiffs' motions to compel discovery from defendant NAFCARE and to seal certain documents. And it reflects my experiment using Google's Notebook LM to summarize the case. Plaintiffs sought documents related to external audits of NAFCARE's medical services in Washington State and internal documents reflecting risk management and quality improvement efforts at Pierce County Jail, arguing these were relevant to his Monell claim, which alleged that NAFCARE's policies and practices prioritized profit over patient care. NAFCARE argued the results were overbroad and irrelevant, particularly those seeking audits from other facilities. Washington Magistrate Judge Teresa Fricka granted the motion to compel, citing precedent from similar cases, Tapia versus NAFCARE and Rapp versus NAFCARE, which is a case we covered last year, where such discovery was deemed relevant to Monell claims and found the request reasonably tailored to a 5-year period in facilities in Washington, stating district courts addressing discovery-related disputes in cases involving Monell claims have routinely recognized that such claims often require a broad and substantial amount of discovery that would not be involved if the plaintiff sued only the individuals directly involved in the deprivation of his rights. She also granted the motion to compel related to information about NAFCARE's corporate structure, including related entities, shareholders, officers, and their compensation, as well as documents detailing NAFCARE's budget, expenses, and profits related to its operations at Pierce County Jail, finding that the information was relevant to both the Monell claim and potential punitive damages. She also ordered NAFCARE to provide a privilege log for any withheld documents and denied the motion to seal a 2015 NAFCARE proposal for services at Pierce County Jail, finding that because the information was easily accessible online, NAFCARE had not demonstrated that public disclosure would cause them harm, stating the Ninth Circuit has applied a strong presumption of public access to judicial records. So, Mary, what makes discovery unique in cases involving Monell claims compared to standard civil litigation?
Well, I had to look this up, Doug.
Me too.
So for a Monell claim to survive, the plaintiff must establish that the public entity had an unconstitutional policy, either by an actual written policy or by an unofficial custom or practice exercised repeatedly. And because most public entities won't put in writing unconstitutional policies, or at least they don't do it that often, you have to dig deeper. To sustain the burden of proof, the plaintiff typically makes a public records request for the policies and training practices, and then conducts depositions of multiple staff to determine if there's a frequency of the alleged behavior to support the action. So that's why they need to go deeper. It surprises me that they allow, that there's a different standard of discovery in this area.
Yeah, it is to me too. And like you, I had not heard of Monell claims before. So when I ran across it, I thought, well, this is an interesting case to cover for that reason. So there we have it, something new we've learned here. So Tom, it seemed as though NAFCARE used the term overbroad to object to the plaintiff's request several times, but did not seem to provide specificity as to how the request was overbroad in most of those objections. If they had provided specificity to their objections in terms of maybe level of effort required to respond, do you think that would have made a difference?
Well, maybe, on a point-by-point basis. I mean, certainly, as Mary said, the standard is much broader in these sorts of claims. So you quoted the court right there. These require a broad and substantial amount of discovery that would not be involved if the plaintiff was suing only the individuals in a specific action. What's interesting to me is, and I can only claim that I had heard of Monell claims because they're kind of common up in the state of Washington. I don't know how common they are elsewhere in the country, but it's a Supreme Court case. The Monell case, Monell versus Department of Social Services, a U.S. Supreme Court case from 1978 that established the claims in this criterion. So it's been around for a while. Maybe they're called something else in other jurisdictions. So
no, they are called Monell claims in court in New York.
everywhere, yeah. And common there, Your Honor?
Very common.
Yeah, yeah. So I think the standard is broad, as the judge pointed out. And I should also point out that when I called my friend Russ Aoki, attorney Russ Aoki, up in Seattle to talk about this, he said that's Chief Magistrate Judge Fricky. She was named the Chief Magistrate Judge back in March of this year. So just to be clear. But yeah, I think it's just a broad standard, and if you want to counter what's going on there, I think you do have to get specific. Yes.
Yeah, certainly does seem to be the case. We see a lot of objections that still look awfully boilerplate. And we know Judge Peck doesn't like those because he's had a case where he's mentioned that. But I'll ask you different.
Fisher against Forrest for the audience's benefit.
Exactly. Yes. Just about to say yes, where he said no more, and we're still seeing them. But alas. So Judge Peck, how does the need for broad discovery in Monell claims balance against the proportionality principle under Rule 26b-1?
I mean, proportionality still applies, and that may well be, as you were talking with Tom and Mary, the problem with Pierce County's argument here is they didn't drill down. The other point I would mention is it is often, or at least it's not unusual, for the court to stay discovery on the Monell claim, have the direct claim against the individual doctors, or this often comes up in excessive force claims. So, you go forward with the direct claim against the officers, you see how that works out. And then if necessary, you go back to have discovery for the Monell claim and a separate trial on the Monell claim, just to avoid the broad scope of discovery that is needed for most Monell claims.
Yeah. It's definitely seems like they could have made a better argument, and it seems like they've had a few cases where they've had challenges. So
yeah, which not to say that prisoners don't sue right and left,
right,
but the fact that this is the third case about the health care they're providing to the inmates in Washington probably is some indication of the level of health care that is not being provided.
Yeah. Third case in probably a little over a year, if I remember correctly. I think the RAP case we covered last year was fairly late in the year. So, yeah, not a good indication for them. We'll move on to the next case, which involved claims pertaining to defendants' oil and gas royalty payments and the propriety of deduction of post-production expenses under its oil and gas leases, where the plaintiffs sought to certify a class action. To that end, the plaintiffs had previously sought, via previous motion to compel, copies of defendants' West Virginia oil and gas leases. Ultimately, the court ordered that defendant must produce a subset of its West Virginia leases, which it did. However, plaintiffs took issue with defendants' redactions of those leases. The redacted information seemed to concern things like the names of parties to the leases, the addresses and locations of parties to the leases, book and page numbers indicating where the instruments are publicly recorded in a given county clerk's office, notary stamps, dates of the leases, and the locations of the wells, which are the subject of the leases. In other words, just about everything you would care about in a lease. So plaintiffs filed a second motion to compel, requesting that defendant be ordered to produce unredacted versions of those leases. They argued that the redacted information was needed to attempt to certify the class, to more concretely determine the number of leases and class members at issue, and determine whether the named plaintiffs were adequate class representatives and would be crucial in actually identifying the class members. Note to self, you see the slides better. Defendant argued that the information was properly redacted because, until a class is certified, defendant did not want its royalty owners to be contacted, and also argued that the redaction was consistent with the approach which this court allowed in a similar matter pending in this court, which you see there, the Romeo case. West Virginia Magistrate Judge Michael Alloy stated, plaintiffs helpfully contextualized the court's approach in Romeo vis-a-vis the discovery dispute in the instant matter. During one discovery dispute in Romeo, the court allowed Antero to redact certain information contained in the leases produced in the discovery. In so doing, the court relied on the representation that having pay numbers rather than royalty owners' names and other identifying information would allow a plaintiff to precisely ascertain the information needed to certify the class. In theory, such an approach made sense, but as a practical matter, it appears that the approach was inefficient and confounding, resulting in further discovery requests and disputes, which could have been avoided if unredacted leases had been provided in the first place. He also noted that the Romeo class involved fewer than 400 leases as opposed to more than 8,000 for the present matter. In ruling that defendant must produce the unredacted leases, Judge Alloy stated, unredacted records will allow for a much more efficient process to identify the putative class, given the nuances of appellation, mineral title, and leasing. The review which plaintiff's counsel will undertake, even with unredacted information, is daunting enough. It becomes a practical impossibility with the redactions in place. He also noted that the bulk of the materials which defendant has provided are actually a public record. Thus, there is no compelling reason to designate them as confidential under the protective order, and defendant may not do so, which sort of makes you wonder what the fuss was all about. So, Tom, how does discovery related to potential class certification differ from discovery related to the claims and defenses of the case?
Well, much like the Monell standard that we were talking about in the previous case, it's broader than the facts surrounding the individuals. You have to certify the class first. And so it's about that process, what the court called a process that will most efficiently allow the parties to evaluate the commonality and typicality requirements in the certification phase. There's basically four things. Is the proposed class numerous enough? Does it present common questions? Is the class representative really representative of all of the other people? And are the class representatives' claims typical of all of the class claims? So you've got to go through that whole process, and you're given a wide degree of latitude to do that, as the court pointed out in the last paragraph. That standard is daunting enough with these 8,000 individual investigations or leases that have to be looked at, and so you're just allowed to do it, and then. To your point, which is a real head scratcher to me, if most of them are public record, what are we in here talking about? If most of those things are public record, I don't really get it. But
nor do I. But
just one comment, which is sometimes it is really easy to differentiate the discovery that should be permitted for class certification versus the merits discovery. And
right.
At other times, the two are so interrelated that it's a problem.
Gotcha.
I can see how that would be the case for sure. That makes sense. So Judge Peck, it appears Judge Alloy acknowledged that he made a mistake in approving the approach to redactions in the Romeo case. Have you ever made a decision in a case that you wish you'd handled differently?
Well, of course, I was perfect and never, ever made a mistake. Just ask my wife how well that line goes over at home. So, yes, of course, it happens. And thinking about it, I remember one that just stands out. It was a discovery, misconduct or failure to conduct discovery. And the plaintiff's lawyer was basically saying it wasn't me, it was my client, and excuses. And I just said, I don't know whether it was the lawyer or the client. The lawyer is a representative of the client, so the punishment or sanction or whatever was at issue was going to be imposed upon the client. 6 months or a year later, I open up the New York Law Journal and see that this same lawyer was sanctioned in 2 cases in our district and the Eastern District in New York for the same discovery misconduct for a different client that she was saying in front of me was not her, was the client. And I was saying, I blew that one. Should not have been imposed upon the client, should have been on this lawyer. And, you know, judges talk, we do talk about lawyers who misbehave, but not as fast and as much as perhaps we should. So I regretted that one.
Yeah, well, I mean, you went by what the lawyer said, so it's understandable why you would have made the decision you made. But yeah, it certainly is interesting that, you know, a judge can acknowledge, hey, you know what, this, maybe I should have handled this differently. So kudos to you for acknowledging that, and kudos to Judge Alloy for acknowledging it, that in this case. So Mary, what recommendations do you have for our audience about deciding whether to pursue class certification in a case, and best practices to pursue certifying the claimants as a class?
Well, Tom put out the criteria for a class. So of course you want to make sure you actually have something with commonalities of law or fact. And also that you can ascertain who the class members might be. I mean, is there a database that has them? Like, as in this case, you know, it's public record, but they wanted it produced a different way. But this is an area where breach notification, which sort of leaned on eDiscovery technology, especially in the beginning, because it's able to find personally identifiable information. There's a notification process in breach notification that could be leveraged here in class certification and communication, or even the legal hold functionality, because that's also notification and then getting back responses and tracking them. But definitely this is a database issue where you've got to organize your data by jurisdiction and by elements of law and facts.
Yeah, and it's a lot of work and very time consuming, and I've worked on a couple of those databases, so definitely I understand what that's about. So yes, and I hadn't drawn the parallel to breach notification, but yeah, there definitely are some good similarities there for sure. So interesting case, and we'll move on to the next one. And this is a case involving something I've never encountered before: production of a destruction unavailable log, which was covered by Michael Berman on the EDRM blog and his eDiscovery LLC site, which is, in this case being one of many, he does a great job of covering. So definitely you should check out his cases, because he really finds consistently very interesting cases and has very interesting observations about them. In this case, against 18 defendants, including defendant Bedford, the parties submitted a stipulated eDiscovery specification in February 2023. Plaintiffs propounded on Bedford document requests, which called for Bedford to produce documents in a specified format consistent with the stipulated protective order and the eDiscovery stipulation, and to provide specified information regarding responsive documents that were destroyed, lost, or otherwise unavailable, i.e. a destruction unavailable log. Over several months, the parties corresponded on the status of Bedford's response to the production request several times, during which Bedford made 2 productions, as you see there. After Bedford's counsel continued to fail to respond to plaintiff's satisfaction, plaintiff's counsel filed the motion to compel, asserting, among many other things, that Bedford failed to produce a destruction unavailable log as required by the instructions in the document requests, and argued that Bedford should be required to do so. California Magistrate Judge Jacqueline Chulgian, and I looked up that pronunciation, that is how it seems to be pronounced, noting that Bedford does not directly address this argument, but does essentially represent that it has never had documents responsive to a couple of document requests, stated the motion to compel is granted to the extent it seeks an order compelling Bedford to produce a destruction unavailable log consistent with the instructions in the document requests, and defendant Bedford is ordered to do so. And that's literally all she had to say about that. After also granting plaintiff's motion, at least in part, for almost all of 37 specific document requests, Judge Chuljian considered plaintiff's request for sanctions, stating, in light of the foregoing, the court deems it appropriate to grant plaintiff's motion to compel, in part to the extent it seeks an order compelling Bedford and its counsel jointly and severally to pay a portion of the fees costs incurred with in connection with the filing of the motion to compel. So she ordered that Bedford and its counsel jointly and severally shall pay monetary sanctions the amount of $5563.50 to plaintiffs. So I'm going to, for the first time, ask all three of you the same question as part of my questions that I'm asking. So Judge Peck, have you ever seen a case where a destruction unavailable log was requested? And if so, and would you have granted the request for it if you were the judge?
I'm glad I get to go first on this. I have seen such a request as part of the boilerplate instructions in virtually every request for production ever in the last 40-something years of practice. Normally, and I am trying to get my colleagues at DLA not to do that. I'm not sure if I'm successful all the time or not. Usually that request is ignored, which isn't necessarily safe, or it's objected to, and that's the end of it. I have never, ever in 40 plus years of practice, and I note that Mike Berman said the same thing, seen it come before a court. Now, someone is going to go on eDiscovery Assistant and find some case that we're all unaware of, but I have certainly never seen it or focused on it. And I think here, the fact that the defendant was problematic with respect to all of its responses or not on the discovery issues, the fact that they did not directly address this, and that to a certain extent being ordered to produce the log when there was nothing that would get listed on the log was, a punishment without any real meaning. And I wish there had been a lengthier decision of why, why this is appropriate. One other point, and, this is an instruction in a request for production, but it's really an interrogatory. Please tell me what has been destroyed. And I'm waiting for some clever lawyer to say, you had this in your instructions. That was the equivalent with its various parts of 5 interrogatories, counting the subparts. And therefore, under the federal system where you're only allowed 25 interrogatories, you're down to 20, even though you didn't respond here, but it was there.
Oh, it's a great point. Yeah, that's a good way to look at it. And some definitely information I learned there. By the way, Craig Ball points out that Judge I struggled with this name so much in practice. Judge Chuljian was the jurist in the general data case of Columbia Pictures v. Bonnell many years ago. So interesting fact there. So Mary, have you ever seen a case where a destruction unavailable log was requested? And how would one even go about constructing such a log, since it's often difficult to know what files have been destroyed?
Yeah, I agree with Judge Peck. I've never seen one adhered to or answered. But generally, a party will disclose that they might have some routine information governance activities where some files might have been disposed of prior to the trigger, the preservation trigger, or certainly maybe after the trigger, maybe offboarding an employee or during migrations or some kind of system outage or a breach. But that wouldn't be in log form. That would be like an overall description of like a loss of amorphous data, if you will. If you're looking for a log, you'd have to do it forensically and look for deleted files that didn't come back in their entirety, because if they came back in their entirety, they're not unavailable, and they'd be in fragment form. And then you could make a log out of that, but that seems to be a lot of work for something that pretty much people ignore.
Yeah, absolutely. No, to me, it seems like something that is at best difficult and at worst impossible for a lot of it, and makes you wonder if a proportionality argument could be given there, at least in terms of specifics. But interesting that it was involved in this case. So, Tom, have you ever seen a case where a destruction unavailable log was requested? And do you think the fact that most of the requests for production were granted, at least in part, and the court found sanctions were appropriate, influenced its decision on ordering production of a destruction unavailable log?
Well, maybe, since there were so many of them. I'm sorry, to answer your first question, no, I've never seen a specific request for a log, but I have seen, much as here and as Judge Peck pointed out, standard language in requests for production to produce something. So then what I have seen is similar to this, when that sort of information was not provided, when there was just a general, we don't have it. I've had cases that, like here, requested specific information, produce a list of the documents you don't have. So I guess, and why, and, if they weren't sufficiently answered in the response to the request for production. So I guess that's sort of like a log, but I think you're right. I think perhaps the fact that so many were found to be not in compliance, perhaps the judge just thought it would be easier to have them compile that sort of a log.
Yeah, evidently. Certainly, with 37, I think, requests for production that the court went through, it was a very long order. So we really just tried to focus on this one issue. It certainly sounds like the defendant had a lot of discovery issues, and maybe that was a factor. So interesting.
Doug, I just want to bring up one point, going back to the first case we discussed today, Cook, of why didn't they ask for costs? Here, the judge awarded $5,500 and change, which, is pretty much small pennies in most big cases. Query whether, they spent 20, they asked for 10, they got half or whatever. Okay. Is it really, worth it to get that amount of sanctions, other than, for psychological effect and for being able to say, opposing counsel, who was sanctioned by the court, earlier in this case, has once again misbehaved.
Right. Yeah, true. A great point. And one would think they spent a lot more effort in this particular motion than the Cook case, which was over kind of one single issue. So, yeah, great point. And with that, we'll move on to our last case, which involves alleged violations of the False Claims Act and various state laws, and is another case covered by Michael Berman that we decided to cover too. Defendant first served its Rule 30b-6 deposition notice on July 3rd. After several subsequent meet and confers, defendant sent a letter on September 13th summarizing what it contended was the resulting agreement with the state of Washington. Washington responded by email 4 days later, informing the defendant that there may be a need for additional discussion about narrowing the scope of the 30b-6 topics. As the aptly named Washington District Judge Benjamin Settle stated, Washington argues that NNI's 51-topic Rule 30b-6 deposition notice is overbroad and unduly burdensome, and denies that it ever agreed to prepare and produce witnesses to testify on those topics. It suggests that it has not begun preparing witnesses, and that parties are continuing to refine the Rule 30b-6 topics. It moves for a protective order, narrowing the topics and setting specific time limits. Washington does not propose the terms of such an order, describe specifically which topics are overbroad, or propose the time limits it asks the court to impose. Its cross motion for a protective order is therefore denied. He also noted that the issues addressed by Washington's proposed draft revisions to NNI's notice were minor, but now claims that the entire notice is overbroad and unduly burdensome, and it would be a waste of time for Washington to prepare its witnesses to testify about them. Granting defendant's motion to compel, Judge Settle stated, the court need not resolve the factual skirmish over whether Washington agreed to the topics in NNI's Rule 30b-6 notice to resolve the motion. The state's newly minted objections to the deposition topics come far too late and are not persuasive. Topic 35, for example, goes to the heart of NNI's defense to Washington's $100 million plus claim against it. It is not unduly burdensome to force a plaintiff to permit discovery into issues that are a core part of her case. Regarding confidentiality designations, Washington asked the court to compel defendant to de-designate older documents it claimed defendant improperly designated as confidential under the party's amended protective order. As Judge Settle stated, Washington argues, and its 1,900-page filing seems to support that NNI made blanket confidentiality designations adversely impacting Washington's ability to file evidence in open court. He also noted in a footnote that the court has not read the entire submittal. Gee, why not? Ruling on the dispute, Judge Settle stated, NNI's assertion that Washington itself seeks blanket de-designation is accurate. The court will not go through the designations one by one, just as Washington's filing does not go through them one by one. How could you know? It's 1,900 pages. It does broadly agree with Washington that blanket confidentiality designations are improper. But he added, it is not productive to litigate confidentiality designations in the closing days of discovery when substantive discovery remains to be completed. Washington's motion to compel NNI to de-designate confidential documents is denied without prejudice to raise again in connection with a specific document related to a proposed filing or at trial. So, Mary, how could the state of Washington have handled its objections better to the Rule 30b-6 deposition topics to achieve narrowing the scope of the deposition?
Well, they might not want to use the phrase waste of time unilaterally. That would probably be one thing. But basically shed the blanket designation, start cooperating, don't drag your feet, and get to it. That, in a nutshell, that's what I've got for this one.
Yeah, and it certainly seems like they could have been more prompt with their objections to those deposition topics instead of, just really continuing the hem and haw a bit until the motion was filed. So certainly that seems like certainly seems like it could have been handled better. So, Tom, given that Judge Settle agreed that blanket confidentiality designations are improper, do you think he should have granted Washington's motion to compel and forced the defendant to designate individual documents as confidential?
Well, if this had come up earlier in the litigation, maybe, but I thought the key sentence was right there in that last paragraph. It's not productive to litigate confidentiality designations in the closing days of discovery when substantive discovery remains to be completed. So I think from the judge's point of view, this wasn't an effective use of the court's time and or the party's time. And let's deal with substantive discovery and get that done. He may have been inclined to rule one way or the other, but he resolved it by saying the motion's denied without prejudice. Raise them in connection with specific documents related to a proposed filing or a trial. So bring them in one at a time or in a manageable number at a more appropriate time, and we'll deal with them then.
Yeah, so it makes sense. So Judge Peck, as I mentioned, Washington State submitted a 1,900-page filing to support its motion regarding confidentiality arguments that Judge Settle didn't fully read. Have you ever gotten a filing so large you didn't read it all? And what could Washington possibly hope to accomplish with a filing that large?
to sort of paraphrase the great legal philosopher Yogi Berra, I didn't read everything I supposedly read. Yes, no doubt about that. I suppose in their 1900 pages, they were trying to justify the reason for confidentiality for the blanket confidentiality documents, for fear that if they didn't do it in that much detail, that the court would say, well, you haven't justified it, so, I'm going to say it's not confidential. And I think the judge handled it just right. It was much ado about nothing. Here, had this been a, two-tiered confidentiality approach where it wasn't just confidential, which really only impacted the filing or use in court, but a two-tier of attorney's eyes only, then it would have been more important for the judge to rule on that limited second tier. And just a little bit of legal history, it used to be in the days before ESI and when the number of documents being produced was not huge, where you had to have a very specific confidentiality order that dealt with things more or less on a document by document basis. That quickly became unworkable. Courts didn't want to have to look at several hundred documents, let alone what we'd now be looking at of thousands or millions. And so you were able to do a so-called blanket approach to confidentiality that if it fell in various broad buckets, it could be designated as confidential, subject to individual challenge as necessary. That's, the way things work nowadays. There really is no alternative to it. And when you get to submitting it in court, and there is a very different, that's a friendly standard for confidentiality. For things that get filed in court, particularly things that are part of a summary judgment or motion or a trial that are merits oriented, then the rules in various circuits about public right to access come into play, and it's a much stricter standard. So late in the game like this, there really was no effective way for the court to deal with it.
Certainly makes sense. For perspective, 1900-page filing is almost 2 copies of War and Peace. So it's, it goes beyond TLDR. It's more like NGR, too long, never gonna read. I think that's that seems like a bit much to me. I thought that was interesting about this case. So with that, now for the contacts page, and I am thankful that I probably won't have to find new cases for our December case law webinar 3 weeks from today, because we're as Kaylee mentioned at the outset, we are discussing the top cases of the year, all 32 of them. No, just 6. I say probably because if we do see a really compelling case before then, we might work it in. But regardless, join us 3 weeks from today. And with that, I will say thanks to Mary, Tom, and Judge Peck for their terrific insights as always. And I'll turn it back over to you, Mary.
Thanks, Doug. And we just are so grateful to you, Doug, for anchoring. And we're grateful to Tom O'Connor and the Honorable Judge Peck for this wonderful presentation. Our thanks to the EDRM community for your kind attention. If you really loved it today, show Judge Peck, Tom O, and Doug Austin from Houston some love. Find your emojis at the bottom of your console. To be automatically registered for on-demand webinars, click the pop-up at the conclusion. Once there, click the bell to subscribe for updates. And we'll see you next time on the EDRM Global Webinar channel. Thank you.
Bye, everybody.
Happy Thanksgiving, all.
Thanks, folks.
Happy Thanksgiving.